Good day, and thank you for joining us in this Property Buyer's Guide session. My name is SchoemanLaw. Thank you so much for joining us today. A warm welcome to each and every one of you. I will be one of your presenters. I am joined today by a panel, each of us bringing a specific perspective and area of focus to the table, and ultimately to ensure that if you are embarking upon the large investment of property acquisition, whether it be for primary residence for you to live in, or whether it be for investment purposes, that you are adequately prepared and that you know that there's a team ready to support you should you choose us for this purpose. So without any further ado, let me share today's agenda with you. In today's session, we will be dealing with freehold property, what to look out for, what are the right questions to ask, and what to really scrutinize. We'll also be looking at sectional title. We'll be looking at what to expect from the transfer process, the conveyancing process, in other words. And then, last but not least, we'll look at tenant rights, we'll look at evictions, and how to put some of the building blocks in place to avoid the eventuality of having to evict a poor paying or non-paying tenant. Before we get into the nuts and bolts of the session today, I think it goes without saying that buying property, whether it is for investment purposes, whether it is to own your own holiday accommodation, or whether it is for own personal use, primary residence, it is a big decision. For many of us, a decision that will only happen a handful of times, if not just once in our lifetime. It is high risk, and therefore it is so important to ensure that we know the process, we know which are the right questions to ask, what should be scrutinized, what should be looked at, in order to protect ourselves as adequately as possible.
Hi, my name is Annelies Petzer, and I will be delving into buying a freehold. So you might be asking, what is a freehold? So in South Africa, owning a freehold property means you have absolute ownership of both the land and the structures on it. This form of ownership grants you significant control and a sense of permanence compared to leasehold agreements. It's a commitment to the property and its potential for the long term. This type of property is typically not subject to leasehold agreements, allowing the owner to make decisions about the property without having to answer to a landlord. So you need to ensure that the seller is in fact the owner of the property. This isn't just a legal formality, but it's also a safeguard against potential disputes and complications. Before purchasing a freehold property, it's essential to verify that the seller is indeed the owner of the property. This can be done by checking the title deed and other legal documents, as well as contacting the local municipality to confirm the property's ownership status. Another consideration is the voetstoots and defects. So this term essentially means that property is sold as is, placing responsibility on the buyer to thoroughly inspect the property. When buying a freehold property, it's crucial to inspect the property for any defects or issues known as voetstoots. These can include structural problems, electrical or plumbing issues, or other concerns that may affect the property's value and habitability. It's essential to identify any potential issues before purchasing the property to avoid any unexpected costs or complications down the road.
Hi, I'm Sizimhlongo. I'll be delving further in buying a freehold. Firstly, title conditions. Every property comes with a unique set of restrictions and encumbrances outlined in its title deeds. Understanding these conditions is crucial as they can impact how you use and develop the property. The title of a property is a legal document that outlines the property's ownership and conditions or restrictions associated with it. Before purchasing a freehold property, it is essential to review the title to ensure that there are no unusual conditions or restrictions that may affect the property's use or sale. Zoning. Zoning regulations, often overlooked but immensely impactful. These regulations categorize and control land use, influencing the property's current and future value. Zoning refers to the designated use of land in a specific area, such as residential, commercial, or industrial. It is crucial to check the zoning of a property to ensure that it aligns with the intended use of the property. If zoning is incorrect or restrictive, it may limit the property's potential use or development. Check building plans approved. Ensuring that all structures on the property have proper approval is essential. It's about ensuring that your property complies with the legal standards and is poised for a seamless future. Before purchasing a freehold property, it is essential to ensure that any building plans have been approved by the relevant authorities. This includes checking for any necessary permits, certifications, or approvals required by local building regulations. Rates account payments to be up to date. Finally, let's talk about the financial health of your property, ensuring the rates accounts payments are up to date. This isn't just a matter of financial responsibility, it directly impacts your property's standing. It's about safeguarding your investment and avoiding financial pitfalls. When buying a freehold property, it is crucial to ensure that any rates or taxes associated with the property are up to date. This includes checking for any outstanding rates, levies, or other financial obligations that may be transferred to the new owner. As we wrap up our exploration today, we've covered the essential checkpoints on your freehold property purchasing journey, from establishing a clear understanding of freehold ownership to navigating potential challenges such as footstool, title conditions, zoning, building plans, and rates payments. Each step contributes to a well-informed decision. By addressing these key areas during the purchase process, prospective buyers can make informed decisions and avoid potential issues or complications when buying a freehold property. Remember, your property is a unique investment, and seeking personalized legal advice is key to a successful and secure transaction.
Hi there, my name is Robin, and today I will be talking about what a sectional title is, as well as looking at the community schemes ombud services, and then taking a quick dive into these schemes' finances. So, a sectional title unit consists of a part of a building or a separate building on a piece of land that has been converted into a sectional title scheme. The owner's ownership of the unit includes ownership of an undivided share in the common property. All the sections together with the common property comprise the scheme. Now, the community scheme ombud services, also known as CSOS, was established in terms of the Community Schemes Service Act 9 of 2011 to regulate the conduct of parties within the community schemes and to ensure good governance. The community schemes are defined in the CSOS Act as living arrangements where there is shared use of and responsibility for land buildings such as sectional title, homeowners associations, retirement housing schemes, share block companies, and housing cooperatives. The mandate of CSOS is to regulate, monitor, and quality assure scheme governance documentation, develop and provide a dispute resolution service, provide training for conciliators, adjudicators, and other employees of the CSOS, and take custody of, preserve, and provide public access electronically or by other means to scheme governance documentation. Now, in terms of the scheme's financials, this prescribed management rule requires the following. It requires that a body corporate must, in its annual financial statements, account for all the contributions and any other charges debited to members' accounts. Further, body corporates must, on request in writing by a member, make available a full and detailed account of all amounts debted and credited to the member's account within the body corporate. The body corporate must also have an annual financial statement, and this must include the following: the amounts due to the body corporate in respect of contributions, special contributions, and other charges, which are classified by the member and the periods for which such amounts were owed. The amounts due by the body corporate to its creditors, the amounts advanced to the body corporate by way of levy finance, the amounts in the reserve fund, which show the amount available for maintenance, repair, and replacement, as well as premiums and other amounts paid and payments received by the body corporate and any member in terms of the insurance policy of the body corporate and the expiry date of that policy, as well as includes the amounts due and payable to the Community Schemes Ombud Service. The body corporate must also present audited financial statements to a general meeting for consideration within 4 months after the end of year financial year. The body corporate must also keep proper books of accounts
Hi,
that
my name is
record all its
Celeste and I'll be
income,
talking about buying
expenditure,
sectional
assets and
titles.
liabilities,
Purchasing
disclose
a
all
sectional
amounts
title
recovered
property
from
is a
members by the
significant
body
investment
corporate or any
that
managing
involves not
agent
just finding the
or
perfect
other
living
service
space,
provider
but
acting on
also
its
navigating
behalf.
a complex web of rules and
Include
financial
individual
considerations.
accounts of each
To
member
ensure a smooth
and
transaction
contain
and a
all other
harmonious living
information
experience,
necessary to
prospective
allow
buyers
members
must
to
pay
assess the
careful
body corporate's
attention
financial
to the
situation
management
and their
and conduct
financial
rules,
situation in
as
regard to the
well as
body
verify the
corporate.
up-to-dateness of
The
both
body
rates
corporate
and
must
levy
also keep
account
separate
payments.
books of account and
Sectional
bank
title
accounts
owners
for its
refers to a
administrative
system
and reserve
when individual
funds.
owns a unit
The
within a
body
larger
corporate must also
complex
prepare
or building,
budgets for the
sharing
administrative
common
and reserve
spaces
funds,
and facilities with
comprising
other unit
itemized
owners.
estimates of the
This type of
anticipated
ownership
income
comes with
and
unique rules
expenses
and
during the next
responsibilities,
financial year for the
making it essential
presentation
for buyers to
at the
be well
next
informed.
AGM.
The first step is to reviewing management and conduct rules. One of the first steps in purchasing a sectional title property is reviewing the management and conduct rules that governs the community. These rules outline the rights and obligations of unit owners, specifying matters such as noise levels, pet policies, and guidelines for alterations to individual units. It's crucial for potential buyers to carefully read and understand these rules to ensure compatibility with their lifestyle. Buyers should obtain a comprehensive breakdown of the levy account, examining the payment history and ensuring that all financial obligations have been met by the current owner. This step is vital in avoiding unforeseen financial burdens and contributing to the overall well-being of the community. In conclusion, buying a sectional title property involves more than just finding the perfect living space. It requires a thorough understanding of the rules governing the community and diligent financial scrutiny. By carefully reviewing the management and conduct rules and ensuring that the rates and levy payments are up to date, buyers can be informed to make an informed decision that contribute to a positive living experience within the new sectional title community.
Now, the conveyancing process or property transfer process essentially is triggered by the offer to purchase. The offer to purchase is made by the buyer. Once accepted by the seller, becomes legally binding and is thereafter referred to as a deed of sale. Now, in industry, we often refer to an offer to purchase, or OTP for short. The point is that sale agreement has become legally binding. That is when the process is essentially started. Thereafter, we will look at any suspensive conditions that would need to be met. Typically, this would be, for example, to obtain bond finance, which is usually a period of 2 to 3 weeks from the date on which the offer to purchase has become legally binding. Another example could be that you as the buyer would need to sell your existing property in order to fund the purchase of this property that you're seeking to buy. Those are the two most common suspensive conditions. After the agreement has become unconditional, the process really gets started. That is the point on which your conveyancing attorney will contact you for purposes of paying their fees. The estate agent will start the process of arranging for the compliance certificates, which are typically electric compliance certificates. In Cape Town, it would be a plumbing certificate. It could also involve electric fence, gas, and beetle, for example. It depends what is applicable to the property concerned. And the estate agent, usually dealing with the transaction, would know which of these certificates would apply. But as a rule of thumb, your electric compliance certificate is usually always a requirement. Then, of course, it is important for you to ensure that you've contracted around defects and repairs that would need to be conducted before the transfer is finalized. Now, again, that would usually be listed under the other conditions section of the offer to purchase. Then it is important to find out where the original title deed is. If the property is bonded at the point of it being sold, then the title deed is likely to be with the bond holding bank. If it is bond free, it should be with the seller. Often it happens that these documents become misplaced or destroyed, in which case a certified copy would need to be obtained before the process of transfer can be fulfilled. Of course, the conveyancing attorney will have to do a FICA check on both buyer and seller. The documents will be populated and signed. Once the documents have been signed, this would typically be a power of attorney to pass transfer signed by the seller, and a new title deed which will be signed in the presence of the registrar of deeds by the conveyancer. One would then ensure that all the external components have been applied for and are in place. These would be the compliance certificates I mentioned earlier. The transfer duty should be paid with SARS and a receipt should be issued. Then, of course, the rates clearance, and in the case of a homeowners association or sectional title, a levy clearance certificate should be obtained. Once all of this is in place, we can lodge in the deeds office, depending on the time of year and depending on the deeds office concerned. Registration takes place around 7 to 10 days after lodgement. It could also happen that there are adjustments needing to be made to the documents, in which case it could then mean that those corrections need to be made, and a few days could delay the process, and therefore that a relodgement could be necessary. But again, the conveyancer will detail this and the eventuality of this potentially occurring. It also depends on whether there's another attorney involved dealing with the bond and another one dealing with the cancellation of the existing bond, and so on and so forth.
When buying a property for investment purposes, and more specifically wanting to rent it out to tenants or prospective tenants, there are a few things that you should take into consideration before doing this. While looking at prospective tenants and going through applications for rental of your property, we would suggest that you conduct a proper background check. Now, what exactly a background check is that you would essentially look into the credit history of the prospective tenant in order to see, can they afford the property? Do they have enough income? Do they have any judgments against them? Or do they have any bad debts? This will be determined by doing a check on the credit bureau, or to just generally check their credit score. And you can ask for certain documents, as in you can ask for 3 months bank statements in order to see what is their cash flow like, and you can also ask for a payslip, which will confirm what their income is. Other things to take into consideration would be to do a background check on, have they rented property before, and if so, do they have any reference letters from previous landlords that can give you an indication of whether or not they're a good or a bad tenant. These are all things that you need to take into consideration in order to ensure that the tenant that you are now allowing on your property will be a good tenant, in the sense that they will not damage your property, that they will pay rent on time, and that they generally have the funds necessary in order to cover all the expenses that the lease agreement would require. Now, on that point, what we would also think that you must consider is that depending on your property, whether you're renting it out furnished or unfurnished, it would be to ask for multiple months deposit. The usual is a month to 2 months deposit, but we would suggest to ask for 2 months deposit. The reason for this being is that should the tenant cause damage on your property, you are assured that there is enough money contained within their deposit to cover those damages. Or should the tenant not have caused significant damage to the property, but had missed a month's rental, that you can recover that from the tenant's deposit. It's why we suggest that depending on the size of the property and the amount of rental that's being asked for, you consider how many months deposit you are asking. That deposit does not have to be payable immediately and can be paid in increments depending on what the parties decide at the time. The other thing to consider is that a lease agreement does not necessarily have to be reduced to writing, but we would advise that you always do that and that you approach a legal practitioner in order to do so. The reason for this is to ensure that both you and the tenant are protected and that the terms of the lease are in line with the Rental Housing Act. This is to ensure that you are compliant with both the law and protected should any unforeseen circumstances arise. It also allows you to determine what is the processes that would happen should, as an example, the tenant want to extend the lease, or the tenant would like to request a certain fixture to be added, or anything that would require the permission of the landlord in that sense. And the lease agreement would therefore put in terms that would set out the procedure that would need to be followed by both parties in order to do that. It also sets out the procedure that would happen in case one of the parties breaches the lease agreement and what the remedies in that case would be.
Now, generally speaking, the rights of the landlord, who is also the landowner or the homeowner, are for the most part unlimited. And of course, the fact that this person or persons in the plural are the owner of the property would mean that certain rights and duties would flow from that. More about that a little bit later. The point is that the landowner or the homeowner would be entitled to make alterations to the property, provided that building regulations are complied with, the relevant plans are filed, and so on and so forth. Of course, zoning or title restrictions, for example, on the height of any buildings or the number of buildings, may also need to be observed and may restrict this general provision. Of course, the landowner or the homeowner is also the person ultimately benefiting from or entitled to receive rental payments. And of course, may have the right to terminate the lease agreement. And last but not least would also be the person ultimately entitled to be compensated for any damage may be suffered to the property. The rights of tenants are well recorded within law and usually, in addition to that, in the lease agreement that the landlord or the landowner or homeowner has with the tenant concerned. Now, this means that there's a dual layer of protection, specifically in instances where there is no lease agreement. The point is that the tenant contracts, whether it's verbally or ideally in writing, in order to take possession of and to habit or to be present and live within the property, to reside within the property. This means that they cannot be arbitrarily dispossessed of their belongings, even when their rental is in arrears. Therefore, if we want to attach any personal belongings of the tenant, we need to follow the correct process in doing so. And this process is usually started with issuing an automatic rent interdict summons. Similarly, the lease agreement cannot be arbitrarily cancelled. The agreement needs to be cancelled appropriately and on the basis of material reasons for doing that. Now, of course, unpaid rental may be a good reason for doing that. Remember, the tenant has the right to privacy. So, although the landlord is the landowner and has a right to visit the property, he or she cannot do so without prior arrangement that needs to respect the right of privacy of the tenant. Now, of course, the deposit, always a contentious issue, needs to be invested under the Rental Housing Act in terms of an interest-bearing account. In other words, this amount needs to draw interest and only reasonable damages or expenses may be set off from this deposit. Yet another good reason why it's good to have a contract in place detailing the types of set-off and the process that will be followed in the case of a set-off. And then, of course, the tenant has the right to be treated fairly and not to be discriminated against. Now, if we look at the obligations that flow from the ownership and potentially allowing tenants to occupy property, the landlord's obligations are very important. Firstly, the landlord needs to ensure that the property is habitable and suitable for the purpose of which it was intended. In other words, that everything is in a reasonable, good working order and of course is safe. The landlord is also responsible for the maintenance and upkeep of the property, unless of course there's an agreement with the tenant in writing to the contrary. Now I keep saying in writing because that is definitely preferable and ensures that we limit the potential of dispute significantly. And then of course we need to make sure as the landowner that all vital services such as water and electricity, are in good working order. On this point, I want to say that remember, when those services are disconnected, that can have the same legal ramifications as the tenant being unlawfully dispossessed of the property. In other words, a spoliation application may follow if the water and electricity services are unlawfully disconnected. It is therefore a good idea to ensure that tenants are properly screened from the start. And if you have a poor paying or a non-paying tenant, to ensure that you get appropriate legal advice before taking any further steps. Now, if we look at the tenant obligations, first and foremost, the tenant is obliged under agreement to pay for the right to occupy the property. Now, of course, when and if a tenant stops doing so, it is not such a simple matter to simply say, well, you've breached your obligation, I am going to do the same. Again, there's a process to be followed in order to avoid incurring extensive legal costs with multiple applications, such as spoliation applications, when the services have been unlawfully disconnected to the property, or when the landlord has done a self-eviction contrary to the relevant legal provisions. So it's really best to ensure that if you are dealing with a poor paying tenant, that you seek appropriate legal advice to deal with the matter swiftly. Of course, it also goes without saying that a tenant has to ensure that they are aware of any house rules. For example, in apartment blocks or sectional title schemes, observing the conduct rules, making sure that you comply with it as the tenant is vitally important. And of course, non-compliance may result in fines being imposed on the landowner or the landlord, which should be recoupable from your tenant. And again, it goes without saying that ensuring that you have a written lease agreement is absolutely vital to deal with issues like that. And then, of course, to make sure that their visitors also comply. And even outside of an apartment complex setup, that some of the basic rules in relation to nuisance are observed. Respecting the rights of the neighbors, switching off the loud music at a reasonable time, or making appropriate arrangements before noise is made in the first place. And then, of course, to not to damage the property, to keep it in a good state of repair, and to hand it back in the same condition as it was received. And then, of course, to report any issues in relation to maintenance timeously to the landlord.
My name is Johan de Lange, and I'll quickly be taking you through just the brief outline of how evictions would work.
That brings us
Now,
to the end
it's
of our
important to
session
note
today. Thank you